Hello everyone, welcome to the No Drone Zone. As always, this is Brennan Youngblood, co-founder and CEO of Drone Security Services and former FAA manager for UA security and counter-UAS coordination. So today I want to talk about Section 2209, which is a new drone-only airspace restriction that Congress required the FAA to create a rule on back in 2016. Now, here we are 9 years later, and there still hasn't been a rule released for public comment and feedback. We have recently seen some movement. As you can see here, as of Wednesday, May 21st, 2025, the Department of Transportation, through Secretary Duffy's announcement, has submitted the Beyond Visual Line of Sight and the Section 2209 proposed rule language for the administration's review and approval. Now, along with the announcement, of course, we have a lot of the positive feedback from the regular associations, Commercial Drone Alliance, AUVSI. API is good because they're doing a lot of the critical infrastructure inspections that they require beyond visual line of sight operating. They also have significant concerns around drones operating around critical infrastructure, which could damage or affect their operations. National Retail Federation, AR, so you can see all these organizations applauding this recent move. So one thing to keep in mind, while this is a good move forward, it doesn't necessarily mean we're going to see the regulation for comment and feedback here anytime soon. It just simply means that the administration is reviewing it, making sure it is in line with the administration's agenda. It fits the need or the requirements that Congress had levied on the Federal Aviation Administration back in 2016. So what is Section 2209? What can we expect from the rule when it does finally come out for comment and feedback? And what are the things that we should be looking for as we provide that feedback on the rule? In order to answer that question, we have to go to the law. So as I said, the original requirement was passed in 2016. And as you can see here, right there, it's Section 2209, Applications for Designation. And if you go down to subsection C, you will find what Congress wanted the FAA to create requirements around for the restriction of airspace, specifically targeting drones over certain facilities. You can see critical infrastructure, energy producing, transmission, et cetera, oil refineries, chemical facilities, amusement parks. The one gotcha on this is this subsection 4 is other locations that warrant such restrictions. Now, that provision put the FAA in a really awkward position because they're a safety-focused organization. Their role is to maximize public access to the airspace so long as it is a safe operation. Security is not within their mandate. Their safety and efficiency. So placing that requirement to assess potential vulnerabilities of structures from drones was not really a solid move by Congress, and they corrected that in later laws, which I'll show you. So as we continue down the law and see this section, subsection under considerations, and within the regulation, it had to spell out how they would make a determination whether to grant or deny such an application of designation. And so you can see here's some of the things that they wanted the FAA to take into consideration. You have aviation safety, protections of person and property on the ground, national security, homeland security. And again, just to reemphasize the point, the FAA is a safety organization, not a security organization. So for them to be determining what is a homeland security or a national security vulnerability is just not within their stated authority. So that creates a little bit of a problem as they try to figure out how to approve or deny some of these application submissions. We're going to jump forward 2 years to 2018. They came back to the Section 2209 rule and they said, hey, there wasn't enough in there. So we're going to strike the language and distribution facilities and equipment, and we're going to insert distribution facilities, equipment, and railroad facilities. So they expanded upon what was originally required on what they wanted covered by this airspace restriction. They also added in, hey, you guys got to get on this. March 31st, 2019, we need something back from you. And now we're going to jump forward again to 2024, where they modified the language again. And in here, what they did is they included the word temporarily, so they could create a temporary Section 2209 restriction rather than it just being a permanent fixed site location, so mass gatherings potentially or others. They also added state prisons into the mix because the FAA currently doesn't have the ability to restrict airspace over state prisons. And kind of what I was alluding to earlier about the security versus safety role the FAA has, they struck the other locations that warrant such restrictions from the law. which I personally think was a really good move by Congress because it gets rid of any ambiguity in what they want covered by these new drone airspace restrictions. So there it is. That's Section 2209, just purely based on legal language and what you should expect to see as far as a framework within the regulation when it does come out for notice and comment. So let's talk about what to look for when that rule does get released for comment and feedback. So the FAA can't just say, hey, send us your stuff and we're going to approve it because you're an energy producing company and you have property that is potentially vulnerable to drone threats. Instead, what the FAA is going to have to do is they're going to have to establish some type of criteria to slim down the amount of chunks of airspace that are going to be denied to drones. Because if you think about it, critical infrastructure or energy producing facilities could be anything from power lines stretched all over the United States. I mean, there's millions of miles worth of power lines. There can't be an airspace restriction over every single section of those power lines to different substations and transformers and all these others. So they're going to have to really qualify that down, most likely through some type of quantitative measure. And that's something you're going to want to pay very, very close attention to, because if you do not meet that criteria and you're assuming you're going to get something like this, this type of airspace restriction, you may not qualify based on that criteria. And so if that's the case, you're going to definitely want to comment on the rule saying, we don't necessarily meet the criteria that you're laying out within the regulatory language. However, this is what our current quantitative measure would be. And if we lost X substation or X transformer or whatever, the entire power could go out to X number of customers, right? And so you want to be able to defend and justify the expansion of whatever that criteria is that the FAA lays out if it's not enough to meet the need of your organization. Based on a lot of the conversations I've had around 2209, there's two more things that I want to point out that you should be looking for within the language for comment period. One is this assumption that there's going to be some type of counter UAS authority or some mitigation authority or something wrapped around being able to shoot down drones that are threatening and inside that airspace. Now, I just went through the law with y'all, and as you saw, there was no mention of counter UAS whatsoever. So that's a bad assumption. So when you do go through that, make sure you look for if there's any mention of counter UAS and what that may or may not mean for your facility, your operations, and your security mission and what you are trying to accomplish. The last thing you're going to really want to look at is what is the penalty associated with a violation. This is the ultimate deterrence in, keeping people out of these airspace restrictions. Just like driving down a road, ultimately the deterrence is having to pay a fine for a speeding ticket. Same concept. Now, the problem with most of the FAA regulatory penalties is it's some kind of civil enforcement, which is a monetary penalty or fee or fine, if you will. And so there's only 3 types of airspace restrictions that exist that have a criminal penalty associated with it. And as far as I know, all of those are misdemeanor violations. It's 91-141, 99-7 SSI, and prohibited airspace, which is a regulatory form of airspace. Now, you'll really be able to see how, I don't want to say how serious the FAA is taking this new regulation, but rather how much weight that they're going to put on it by how much enforcement teeth or penalty teeth they're going to put behind the rule. And the way you'll be able to tell that is when they do push out the reg text is if there is a criminal penalty associated with it. If you do not see that criminal penalty associated with it, there's only a civil fine, and it reduces the burden of violation of that airspace restriction, which, again, in my thought or my opinion, really waters down how severe it is to violate that type of airspace restriction. So there you have it. That's pretty much Section 2209 it wrapped up in a nutshell. Again, this is just shy of a decade worth of evolution in this new airspace restriction and really what's coming out of it. And as with many other UAS security-oriented regulations, they are far behind. I mean, the 10 USC 130I, which is the DoD's counter UAS law, 6 USC 124N, which is DHS and DOJ. Those are coming up on 10 years themselves. And so, Congress really needs to update this legislation, get this stuff moving, and these departments really need to get this regulatory language out in order to provide that legal framework to keep our critical infrastructure and many other facilities safe. If you got something out of this video, please hit that like button. Greatly appreciate it. It helps out a lot. And if you want to be notified on future content, always hit that subscribe button to get that notification. And I will be producing more. If you have anything specific that you'd like me to cover, throw it in the comment section, and I'm happy to create a video on that topic matter. So until then, take it easy.